Well, ladies and gentlemen, good morning. The numbers are now picking up, so I will start now this webinar, the latest in Cornerstone Barristers' series of webinars under lockdown, this morning on financial penalties under the Housing Act 2004, law, practice and procedure. Let me start video so that for the moment at least you can, I hope, see me. Welcome, as I say, to this latest webinar. My name is Dean Underwood, and for those of you who don't already know me or haven't met me, I'm a barrister at Cornerstone specialising in housing law, in public and administrative law and local government law, and I have a particular interest and specialism in licensing under the Housing Act 2004, and as a result of that, in financial penalties under the same legislation. And that's what I'm going to talk to you about this morning. And so, as I said previously at 11 o'clock, you're in the right place if you want to, this morning an overview of financial penalties. We have about 45 minutes. And so what I hope to give you is an overview, albeit a fairly comprehensive one, I hope. And as a result of the short time frame that we have, I've assumed a basic knowledge of parts 1 to 4 of the Housing Act 2004, and some of part 7 as well, the enforcement provisions. I'm going to aim to provide you with a summary of the statutory framework and obviously of the local housing authority's power to impose financial penalties under section 249A of the 2004 Act as, importantly, an alternative to prosecuting various housing related offences in England. In that context, I will aim to give you a brief summary of some of the recent and most significant case law on the subject, including various decisions, I'm delighted to say, some of which members of Cornerstone have been involved in, including myself and various of my colleagues. Waltham Forest and Eunice, for example, Waltham Forest Marshall and Ustek, and perhaps most recently, Sutton and Norwich City Council. As you'll see, I have a PowerPoint presentation on the screen, and I'll move through that very shortly. And as we go through that presentation, you'll find that there are hyperlinks to various pages on the internet. I've aimed to provide you with links there to the material to which I'll refer, whether it be statute, guidance, or codes of practice. If you click or right-click on those links, you should get taken through to that content. You can look at that now or at your leisure. Any queries arising from this, you have my email address at the bottom of the first slide, and please feel free to give me a call or drop me an email about any queries, or if you wish, drop me no hints at all. Feel free to instruct me on any more substantial matters. Without further ado, let's begin. Let's start at the very beginning, skipping through the introductory slides. What are the fundamentals of the statutory power to impose a financial penalty? Let's go back even further. What exactly is a financial penalty? Well, in broad terms, as you'll see from the slide, it is a fine levied by a local housing authority in England on an individual or an organisation as an alternative to prosecution for certain housing-related offences under the 2004 Act. There are various concepts and propositions in there to which we will return in a few slides' time. The fact that this is an alternative to prosecution is an important one. And the number of housing offences in respect of which a penalty can be imposed is currently limited, and we'll go through those in a bit more detail. This power is now about 3 years old, and it was introduced by amendments made by the Housing and Planning Act 2016. In particular, that inserted a new section 249A and Schedule 13A into the 2004 Act. As indicated a moment ago, it's a power that's now about 3 years old, introduced and came into force on the 6th of April 2017, applying to offences committed on or after that date, not beforehand. Now, the primary power to impose a penalty is imposed, as you might expect, in the first subsection 249A. So by subsection 249A1, the local housing authority may impose a financial penalty on a person if it is satisfied, beyond reasonable doubt, that the person's conduct amounts to a prescribed offence in respect of premises in England. Now, a number of points to note there. First of all, that the standard of proof is beyond reasonable doubt. The burden of proof, if you like, is that belonging to the local housing authority. It is the local housing authority that must be satisfied that the person's conduct amounts to an offence. And it only applies in respect of certain prescribed offences. Now, for these purposes, a person's conduct, as you will see, includes a failure to act. And so, for example, a failure to licence, as we will see in a moment, will amount to a relevant housing-related offence. Well, all of that rather begs the question, what exactly are the prescribed offences? These are provided for by section 249A, subsection 2. By my count, if my arithmetic is correct, there are 8 different and particular statutory offences for which a penalty can be imposed. So the first of them, under section 30, failing to comply with an improvement notice, which has been served under part 1 of the 2004 Act. Then managing or having control of an unlicensed house in multiple occupation under section 72, the first of the part 2 offences for which a penalty can be imposed, and there are 3 of those. So in relation to HMOs, permitting an HMO to become occupied by more than the authorised number, the overcrowding offence in short, is one of those for which a penalty can be given, as indeed is failing to comply with the conditions of a licence granted in respect of an HMO under subsection 3 of section 72. Those are the part 2 offences. We then turn to those under part 3 relating to selective licensing as opposed to either mandatory HMO or additional HMO licensing. So managing or having control of an unlicensed part 3 house under section 95 subsection 1 and failing to comply with licence conditions in respect of a licence granted under part 3, also offences which may be penalised. And then we turn almost lastly, penultimately, to section 139, subsection 7, which is in part 4, failing to comply with an overcrowding notice in respect of an HMO that is not required to be licensed under part 2. Again, an offence, one of the prescribed offences in respect of which a penalty can be imposed. And then lastly, by my count at least, failing to comply with regulations made under section 234 of the 2004 Act relating to the management of HMOs. And that, as some of you will appreciate, with the knowledge of the 2004 Act, is an offence created by Part 7. So those are the 8 offences. Now, how does the local housing authority go about exercising its power to impose a penalty? Well, as you'll have picked up from previous slides, the local housing authority must first satisfy itself, before it takes any formal action, that it would have a realistic prospect of convicting the person who would receive the penalty. That is, in other words, proving the offence to the criminal standard of proof if they were to prosecute the matter in the magistrate's court. How does one assess whether there is a realistic prospect of prosecution and conviction? Well, to that end, the statutory guidance, to which there is reference at the bottom of the slide, recommends that local housing authorities consult the Crown Prosecution Service Code for Crown Prosecutors in order to determine whether they have enough evidence to secure a conviction in the magistrate's court. Now, there is a link to that code. I'm not going to take you through it in any detail now, but in brief, there are 2 stages to the process of assessing whether it is possible to decide to prosecute a person and whether there is a realistic prospect of success. The first of those stages is the evidential stage, and the second is the public interest stage. And you'll see all this in the code if you have a look at it in your own time. The evidential stage, as you will gather, requires the prosecutor to satisfy themselves that there is sufficient evidence to give a realistic prospect of conviction, and the public interest test to question and to determine that it is in the public interest to pursue the prosecution. Again, as you might expect, and has become very much public knowledge in recent times because of some significant decisions, local housing authorities are expected to develop and document their own policies to determine when to prosecute and when instead to impose a penalty in the alternative. And they're expected to decide which option to take on a case-by-case basis in accordance with that policy. Now, again, here, local housing authorities have a very wide discretion. That is assisted somewhat by statutory guidance, the civil penalties under the Housing and Planning Act 2016 guidance. It is suggested in that guidance that prosecution may be, but is not necessarily, the most appropriate option where the offence is particularly serious, or where, for example, the offender has a long history of committing similar offences. It is not difficult to conceive, sadly, of cases in which there may very well be serious consequences of, for example, a failure to comply with licence conditions. And one that I dealt with recently involved, very sadly, the death of one person and the hospitalisation of another. That is perhaps the type of case in which the government's guidance rather suggests that prosecution should be pursued as opposed to a penalty. But each case depends on its facts and must be determined on a case-by-case basis. There are, as you will see from this slide, some very significant limitations on the statutory power, and in three particular respects. So, first of all, a local housing authority may not impose a financial penalty in respect of conduct that amounts to an offence under the statute, one of the prescribed offences, if either A, that person has already been convicted of the offence in respect of that conduct, or if indeed criminal proceedings for the offence have been instituted in respect of that conduct and the proceedings have not been concluded. This brings us back to what I said at the very start, that civil penalties under the financial penalties under the 2004 Act are an alternative to prosecution, and they are mutually exclusive. So if you have already started prosecuting and those proceedings are still underway, or if the person has been convicted of the same an offence coming from the same conduct, then you cannot penalise them in addition. Secondly, and importantly, a local housing authority may only impose one financial penalty on a person in respect of the same conduct. And that's by section 249A, subsection 3. It is important to note, however, that where more than one person has committed the same offence, then one penalty in respect of each of them can be imposed. And the example I've given on the slide is, for example, where the person having control of an unlicensed HMO and the person managing it are different, and neither of them has applied to license it under Part 2 of the 2004 Act. In that case, in principle, both of them could be penalised for an offence under Section 72. And then thirdly, as many of you all know, the amount of the penalty that is imposed must not exceed £30,000 per penalty. And that is, as you'll appreciate, an important limitation, a significant one, because if the matter were prosecuted in the magistrates' court, then the magistrates have the power to impose an unlimited fine. There is, however, a cap on the penalty that local housing authorities can impose. Now, as you will appreciate, given that this is a local housing authority procedure, and it is the local housing authority, not the courts, that have to determine in the first instance whether a person has engaged in conduct amounting to an offence, there is an important pre-penalty procedure that must be followed before a penalty can be imposed. So the first step in that procedure is that the local housing authority must serve the person with a notice of its proposal to give a penalty. It's called, in common parlance, a notice of intent. And that's a requirement that is established as part of the procedure under Schedule 13A to the 2004 Act, paragraph 1 in particular. Now, that notice must comply with certain formality requirements. So it must set out the amount of the proposed financial penalty, the local housing authority's reasons for proposing to give it, that is, the offence that's been committed and information about it, and then information about the right to make representations in respect of the proposal to give a penalty under paragraph 4 of Schedule 13A. Now, those, as you will appreciate, are important formality requirements. They are intended to give the recipient of the notice information about the offence for which the penalty is being imposed and the way in which the local housing authority has calculated the penalty so that he or she is able to make representations in accordance with his or her right. Now, a failure to comply with those formality requirements, or in particular to provide a recipient with sufficient reasons for imposing it, is detrimental potentially, but will not necessarily invalidate the notice of intent. And this brings me to a case of Waltham Forest and Eunice, which was taken to the Upper Tribunal by Waltham Forest, instructing my chambers, in inverted commas, dad, no known relation, Ashley Underwood QC. And I'll take you through the decision to which the Upper Tribunal came in a moment. As indicated, though, before we move to that case, a person who is served with a notice of intent has the right to make written representations to the local housing authority about the proposal to give a penalty. And there is a time limit on their right to do so, so they have to do that within a period of 28 days, beginning with the day after that on which the notice is given. So they have a period of 4 weeks in which to make written representations about the penalty decision. So I promised to take you through quickly the case of Waltham Forest and Eunice. It's an important case and deserves a little bit of attention. What are the essential facts? Well, as we know, a notice of intent to impose a financial penalty has to set out the amount of the penalty, the reasons for imposing it, and information about the right to make representations for good reason. Well, in this particular case, Waltham Forest had served on Mr. Eunice a notice of intent for breaching a condition of his Part 3 licence, which was contrary to Section 95(2) of the 2004 Act, one of the prescribed offences under the statute. The facts of this case are quite unusual, quite interesting, and if you have time to read the decision, it's not online, but if you email me, I can send you a copy. It's worth taking a read. Mr. Eunice was essentially running a gambling den from his property and had been causing a nuisance to his neighbours by, for example, hanging dried fish outside of his kitchen window. In its notice and the covering letter which accompanied it, Waltham Forest didn't take the opportunity to elucidate the offence that Mr. Eunice had allegedly committed. But instead of that, it referred to and exhibited a range of witness statements in which details of the conduct in which he'd engaged was set out, and the offence essentially was described. As far as the amount of the penalty was concerned, it referred Mr. Eunice to its online enforcement policy and indicated that the penalty had been calculated in accordance with that. Well, Mr. Eunice applied, as many recipients do, against the final notice ultimately served on him, imposing the penalty, and he argued in that context that the notice of intent was insufficiently reasoned, didn't comply with the statute's formality requirements, and was invalid. Rather surprisingly, I think, to Waltham Forest, the First-tier Tribunal found for him at first instance, said that its reasons were insufficient to enable a valid notice, and it allowed Mr. Eunice's appeal in full. Waltham Forest took that to the Upper Tribunal, as indicated before, and it held that, yes, of course, for obvious and important reasons, a notice of intent must provide a sufficient account of the local housing authority's reasons for imposing a penalty to enable the recipients to understand both what conduct or omission amounted to the offence, and indeed how it had calculated the penalty that it proposed to give him or her. But in this case, it found Waltham Forest had ultimately done so, even though the notice itself didn't contain all of the detail. It had held that there was no reason in principle why a local housing authority's reasons could not be set out in more than one document, as in this case, albeit as a matter of good practice, it said, a concise statement of the facts of the offence in the notice itself would be preferable. And that perhaps is an important point of practice to take from this decision, that in the notice itself set out the brief facts of the case which amount to the offence. It also held that a mere link to an online policy would not be enough to explain the penalty amount. and that there had to be some further explanation of how the local authority had reached the figure stated in the notice. But in this case, again, Waltham Forest had ultimately provided enough information. Importantly, however, and perhaps the most important part of this decision, the Upper Tribunal held that an insufficiency of reasons will not necessarily invalidate a notice of intent. And in that regard, among other authorities, it referred to the case of Nash and Birmingham Crown Court. Have a read of it. There's a link to it in this presentation. And because in this case, Mr. Yunus had not been prejudiced by the lack of reasoning in the notice itself, and he'd been given further information, he'd not been prejudiced at all, and therefore the notice was not defective. He'd made representations pursuant to the notice. He'd never actually complained about the deficiencies prior to going to the First-tier Tribunal, and he'd fully been able to argue his case fairly, both before the local housing authority and the First-tier Tribunal. And so in this case, Waltham Forest's appeal was allowed. An important decision, as I say, if you don't have a copy of it, do drop me a line. Well, there are some important time limits for serving a notice of intent. And so that notice must be given before the end of the period of 6 months, beginning with the first day on which the local housing authority has sufficient evidence of the conduct to which the penalty relates. So it's not dissimilar in some respects from the limitation period that applies in respect of prosecutions to the magistrates' court, but the language is ultimately different. The language of section 127(1) of the Magistrates' Court Act requires in essence that an information be laid, essentially a prosecution begun, within 6 months from the date when the offence occurred or the matter of complaint arose. Now, ultimately, in respect of many of these offences, the prescribed offences under the 2004 Act, the difference in language may not make a difference because some of them have been held to be continuing offences. In particular, the section 72(1) offence as a result of the recent decision in Crown on the application of Mohamed and Waltham Forest London Borough Council, and indeed the offence under section 234(3) of the 2004 Act, failure to comply with the management regulations in respect of HMOs, for which you need to look at IR Management Services and Salford City Council. And the reason that probably doesn't make a difference is because there is a further provision in Schedule 13A which says that if, however, on that day, that is 6 months beginning with the first day on which the LHA has sufficient evidence, the person continues to engage in the conduct and that conduct continues beyond the end of that day, then the local housing authority may give notice of its intent at any time when the conduct is continuing or within the period of 6 months beginning with the last day on which the conduct occurs. Now, pausing for a moment, I can conceive of circumstances in which the language might make a difference. And so, for example, the failure to comply with an improvement notice, it has been held, I think, in Camden and Marshall, comprises potentially 3 different offences. One, a failure potentially to begin works within the time stated in the notice. 2, a failure to complete the works by the deadline given in the notice. And then 3, the ongoing failure to execute works, which has been held as a continuing offence. Now, the failure to comply with the deadline for completion of the works would be, to my mind, a once and for all offence, for which under section 127, time would run from the deadline, the 6 months running from the deadline given in the notice. By contrast, under Schedule 13A, time would not run until the local housing authority had sufficient evidence that the person had not complied with that deadline. So there could be circumstances in which that difference in language makes a material difference. Leaving that subject there, we move on from notices of intent and the period for representations to the final notice that a local housing authority must give if it decides to serve to give a penalty. And so once the period for representations has passed and either the recipient has made representations or has failed to do so, the local authority has a decision to make. Does it impose a penalty or not? And if it decides to do so, it must serve what is called a final notice on the recipient under Schedule 13A, paragraph 5. And that is a notice which gives notice of the intent, the decision to impose the penalty. and requires it to be paid within a period of 28 days, beginning with the day after that on which the notice is given. And again, for obvious reasons, it must comply with certain formality requirements. And so the notice must set out, according to paragraph 8 of Schedule 13A, the amount of the penalty, the reasons for imposing it, information about how to pay the penalty, the period for paying it, well, 28 days, we've already gone through that. Importantly, information about the person's rights of appeal to the First-tier Tribunal, to which we will come in due course, and then the consequences of failing to comply with the notice. And once that notice has been given, that is notice of the penalty, the time for appealing against that penalty will then run from the date that it's given. We'll come on to that in a moment. Importantly, before we do that, a local housing authority may at any time withdraw either its notice of intent or indeed a final notice, or reduce the amount specified in either such notice. And to do that, it gives notice in writing. And that gives local housing authorities a degree of flexibility. Flexibility to, for example, respond appropriately to representations made in response to a notice of intent, or indeed to new circumstances that come to light after it has served final notice of its decision to impose a penalty, for example, mitigating circumstances, which might justify a reduction in the amount of the penalty. So an important power under paragraph 9 of Schedule 13A. Now, before we move on to the right of appeal, time frame for that and process and procedure, how does the local authority go about determining the amount of the penalty? Well, this has been a much litigated issue in recent times. Let's start at the very beginning. So importantly, LHAs may impose a penalty not exceeding, as we know, £30,000 for each prescribed offence. The Secretary of State does have power, as you'll see from the slide, to increase the amounts, the prescribed maximum for that penalty, to reflect changes in the value of money. No such change has yet been effected. There is no statutorily prescribed minimum, however, and local housing authorities have a wide discretion in each particular case to determine the appropriate amount. So to that end, as you've already heard, local housing authorities are expected, the guidance says, to have a documented policy determining, not just as we've seen, how they decide when to prosecute and when to penalise, but also how to calculate the appropriate amount of a penalty in any given case. So generally, the statutory guidance suggests the amount imposed should reflect the gravity of the offence committed, as well as the offender's culpability and history of offending. And the maximum amounts, so the guidance suggests, should be reserved for the very worst offenders. Again, I'd refer you to the statutory guidance on that subject, which you can access by clicking the link. Now the guidance, and I'd recommend that you read it if you are involved in calculating and imposing penalties. You have to have regard to it if you are a local housing authority. That recommends that there are several important factors that a local housing authority should consider to ensure that it reaches an appropriate penalty. And it lists a number of them: severity of the offence, the offender's culpability and track record, the harm caused to the tenant, which includes potential harm caused by the conduct in which the recipient has engaged. And that, as you'll appreciate, is a particularly important factor in this context. The fact that these penalties, albeit an alternative to prosecution, are intended as a punishment, and they are intended to deter the recipient from repeating that offence. And the original guidance, it was reissued in 2018, but the 2017 version contained an introduction from the then Housing Minister indicating that these penalties should be used robustly for that purpose. They are also intended to deter others from committing similar offences, and they are also furthermore intended to remove any financial benefit to the offender as a result of the offending behaviour. So according to the guidance, in addition to that, local housing authorities will also need to consider the resources of the person on whom they intend to impose a penalty, and to, in that context, assess the offender's assets and income. That is a matter which has been reiterated recently by the Upper Tribunal in Sutton and Norwich City Council, a 2020 decision. It's important to note, as that very decision makes clear that the list included in the guidance is not an exhaustive list. So in addition to that, for example, care should be taken not to penalise a recipient twice for offences which arise from the same conduct. And this brings into play what is referred to in criminal proceedings as the totality principle. And it arises commonly, as you'll see from my summary of Sutton on the next slide, in circumstances where penalties are imposed not just against the director, against a company involved in the management of premises, but also against the director of that company. The rationale for that is that in small companies in particular, the directors or director are likely to be the principal shareholders, and so penalising both the company and them for the same conduct is likely to penalise the same person twice ultimately, and therefore the totality principle has to be borne in mind. Take a look in that regard at paragraph 243 of Sutton and Norwich. I've summarised that decision here, and bearing in mind that we are running short of time, I'll only dwell on it very briefly. And this was a case, as I say, in which there had been a penalty imposed on both the company and the director of that company for offences of failure to comply with an improvement notice and failure to comply with HMO management regulations under section 243. And as you'll see, the fines imposed on each of them, 236,000 in each case, were significant. As a result of that, as you'd expect, the director and the company both appealed to the First-tier Tribunal, and it was transferred to the Upper Tribunal because of its significance. And they said, well, look, hang on, the penalties imposed in this case are simply disproportionate, and they offend against the totality principle. And in this case, the Upper Tribunal applied and referred to the case, that you'll see noted at the bottom of the screen, of Crown and Rollco Screw and Rivet Company Limited, which applied the totality principle in this very context. And ultimately it found that, yes, there had been a significant element of double punishment in this case. And ultimately it reduced the penalties imposed to something in the region of, from recollection, 100,000 in each case, something slightly short of that. And so take a look at that. That is a recent application of the totality principle in the context of financial penalties. There are ancillary consequences to the imposition of a financial penalty. And so very briefly, you'll see that those who receive 2 or more financial penalties in a 12-month period may be included in the database of rogue landlords. And although, as the second point on this slide indicates, local housing authorities have a discretion to do that, they are strongly encouraged to do it by the statutory guidance in order to essentially provide a deterrent to others and inform other local housing authorities of those landlords commonly known in the colloquial parlance as rogue landlords operating in their area. And further, obviously, as you might think, local housing authorities may take the fact of penalties into account when considering whether a person who has received 1 or more of them is a fit and proper person to hold a licence, whether that be under Part 2 of the 2004 Act or indeed Part 3. Well, one common issue in respect of financial penalties, in respect of which I receive many questions, is, well, having imposed a penalty, how do you actually recover one? Well, if a person fails to pay a penalty that's been imposed, or indeed any part of it, the local housing authority has the power to enforce it in the county court. And indeed, in that case, that penalty may be recovered in the same way as any civil debt that is payable under a court, an order of the county court. And you'll need to look at paragraph 11 of Schedule 13A to that end. And as a result of that, therefore, penalties can be enforced by way of charging orders and orders for sale, or by attachment of earnings, for example. There are a variety of mechanisms by which local housing authorities can recoup the money that results from penalties. In that case, a certificate which is signed by the local housing authority's chief finance officer and stating that the amount due has not been paid is conclusive. And perhaps importantly for many local housing authorities, and this is not a factor which should feature in their decision to prosecute or penalise, but nonetheless, monies that are recovered by way of financial penalties may be put to use by the local housing authority to cover its costs and expenses under parts 2 and 3 of the 2004 Act, and of carrying out its enforcement functions in relation to the private rented sector. And so by contrast with fines that are imposed in the magistrates' court, local authorities are able to keep the money that results from the commission of a prescribed housing offence. Any amount that is not so applied, however, has to be paid into the consolidated fund. And for those provisions, you need to look at the 2017 regulations, which I've included for you on the bottom of this slide. Well, that takes us rather swiftly through the statutory regime, and I hope provides you with a useful overview of financial penalties and the power to impose them. What about the right to appeal to the First-tier Tribunal? Well, as you will have picked up, no doubt so far, a person to whom a financial penalty is given has a right to appeal to the First-tier Tribunal against either the local housing authority's decision to impose a penalty or the amount of that penalty. And they are not, to my mind, mutually exclusive. It is entirely possible for an appellant to appeal against both the decision to impose the penalty and, in the alternative, the amount of it. So there are time limits for bringing an appeal, and an appellant must provide the tribunal with notice of the appeal within 28 days after the date on which notice of the decision to which the appeal relates was sent to the appellant. And by sent, the reference there is to the date of posting, and the date of posting itself is not included. The tribunal has been held very recently in the case of Pearson and Bradford Metropolitan District Council, has a discretion to extend the time imposed by the tribunal rules, and it has that discretion under Rule 6 of the 2013 tribunal rules. And when considering whether to extend time for breach of or failure to comply with a procedure, such as a time limit, the same approach should be applied as is applied in the county courts and high court under the CPR in response to procedural failure. And you'll find that approach, the three-stage test under Denton and T.H. White, paragraph 24 of that decision. But for its application in the First-tier Tribunal, take a look at the case of Haziri and Havering London Borough Council, which you have a link to on this slide. In the event of an appeal, importantly, a local housing authority's final notice is suspended until the appeal is finally determined or withdrawn, as a result of which, if there is an appeal, payment does not become due under that notice until the appeal has been finally disposed of. I've given you here a summary of Pearson and Bradford, and indeed the Haziri decision. I'm not going to take you through it. With greatest respect to those who are involved in the case, the facts are not particularly interesting, and the propositions of law for which they stand have already been summarised. There is a discretion to extend time, and the principles on which the court should exercise that discretion are set out in Haziri and should accord with the CPR's approach under Denton and White. What about the hearing itself and the procedure before the tribunal? Well, an appeal in respect of a financial penalty is a rehearing of the local housing authority's decision. In other words, it's not a review of the lawfulness of the local housing authority's decision. And in essence, the First-tier Tribunal steps into the local housing authority's shoes as if it's making the decision afresh. But in that context, it may have regard to matters of which the local housing authority was unaware at the time it made its decision. As far as the role of the tribunal is concerned, we have guidance from Clark and Manchester, which says that on a rehearing, an appellant is entitled to expect that the First-tier Tribunal will make up its own mind. And in so doing, it is not required, however, to adopt the approach advocated by the appellant in that case, i.e. of starting afresh with a blank sheet of paper, and it's entitled to have regard to the views of the local housing authority. I'll come back to that in a moment, because the Upper Tribunal has recently expanded upon the reasoning behind Clark and Manchester in the case in which I was involved, that is Waltham Forest and Marshall and Uztec, a summary of which I believe Carolina will be sending to you during the course of this webinar. Importantly, in the case of Eunice, to which I referred previously, it was held by the Deputy President that although, of course, in these appeals, the first-tier tribunal has to consider and decide for itself whether an offence has been committed, the proceedings are nonetheless civil in nature, and they are to be determined according to the tribunal's own procedural rules, applying the same approach as it would ordinarily apply, and not by importing or applying criminal procedural rules. And so one important distinction between pursuing a prosecution and bringing, imposing a penalty is that before the first-tier tribunal, it may well be possible to adduce evidence, hearsay evidence, for example, that might otherwise be inadmissible in the criminal courts. And that is a factor that some local authorities will potentially bear in mind in deciding whether to penalise or prosecute. Now, importantly, as far as the tribunal's powers are concerned, it may determine the appeal by confirming the local housing authority's decision, by varying it, or indeed by cancelling the local housing authority's final notice. If it varies the decision, or rather the amount of the penalty, however, it may not vary the amount of that penalty so as to impose rather a larger amount than the local housing authority could have imposed. It too, therefore, is limited to £30,000 per prescribed offence. Now, I promised to come back to the first-tier tribunal's approach, the proper approach to financial penalties in the context of an appeal under Schedule 13A. And I'll take you through this briefly. Some of you will be familiar with this decision because I went through it recently in my session on recent developments in licensing. This is the case of Waltham Forest and Marshall and Ustek, and it concerns the respect that the first-tier tribunal should show, the deference it should show, not just to local housing authorities' decisions, but also to the policies in accordance with which they're made. And so in this case, Waltham Forest had imposed financial penalties on Mr. Marshall and Mr. Ustek under Section 249A for failing to license flats under their control, in this case under Part 3 of the 2004 Act. Waltham Forest had calculated those penalties according to its own licensing enforcement policy, which it had adopted in accordance with statutory guidance. And that policy imposed a matrix approach to calculating penalties, which was essentially guided by the seriousness of the offence and the culpability of the offender, and categorised in 6 bands in a civil penalties matrix according to those factors. Well, Mr. Marshall's offence fell within Band 2, the lower end of the scale, and Mr. Ustek's within Band 4. And respectively, they were penalised £5,000 and £12,000 for their failure to licence offences. Well, on appeal to the first-tier tribunal, the tribunal reduced Mr. Marshall's penalty to £1,000, that is the equivalent of a low penalty in Band 1, and Mr. Ustek's to £4,000, the equivalent to a high penalty in Band 1. Band 1 being reserved for the least serious type of offences within the civil penalties matrix. Waltham Forest appealed to the Upper Tribunal, and I had the privilege in that case of leading 2 of our very impressive juniors, Riccardo Calzavara and Tara O'Leary. We argued that in its decision, the first-tier tribunals in each case had failed to give proper respect to the local housing authority's policy or indeed to the decision they'd reached. In fact, they paid only lip service to the policies and actually ignored them ultimately in the decision that they'd come to. Now, the first-tier tribunal, it was held by the Upper Tribunal, was not entitled to entertain any kind of challenge to the local housing authority's policy in the context of a statutory appeal under Schedule 13A. If a challenge to the policy per se is to be made, that has to be done in the administrative court. And as far as the FTT's role is concerned, it had to start from the local housing authority's policy, and it should only depart from it in limited and special circumstances. Importantly, in that case, it is the appellant who bears the burden of satisfying the tribunal that it should so depart. What the first-tier tribunal must do when it considers whether it should depart or not is look at and consider the local authority's policy objectives and ask itself whether those objectives can still be met if it departs from the policy. But importantly as well, it must also consider the need for consistency between offenders. That is ultimately the very reason why local authorities have and adopt policies. It is to provide a framework within which they can exercise their wide statutory discretion consistently and transparently. And it's important, therefore, that that policy is applied wherever it is appropriate. In addition to that, it was held, the First-tier Tribunal must afford considerable weight, special weight, to the local housing authority's decision in each case. And the reason for that is that ultimately Parliament has given the primary decision-making function in these cases to the local housing authority. And ultimately it is best placed to know in each individual case where that offending behaviour fits within the matrix of seriousness and the matrix of penalties that it applies under its policy. In this case, as I indicated, and we argued, the First-tier Tribunal had paid only lip service to Waltham Forest policy and its decisions. The Upper Tribunal, in fact, described the penalties imposed in this case as generous, and it reinstated both of those penalties. Well, that, I appreciate, was a rather whirlwind tour of financial penalties under the 2004 Act. We have probably come to the end of the time that we have for the presentation itself. And so I will stop sharing these slides with you for present purposes. And instead, I'm going to share with you a different screen, if I'm able to, which shows the questions that have been submitted both during the course of today and indeed prior to today's webinar. And I'll endeavour to answer some of them within the next 5 minutes. So a question from Hastings Borough Council: when should we prosecute and when should we penalise? Well, the answer to that, I suggest, will vary according to the case that you're considering and should be assessed on a case-by-case basis. You'll need to look at the guidance, and of course the guidance recommends that prosecutions generally be reserved for the more serious cases. They needn't necessarily be so reserved, and you may decide, for example, because of an offender's repeat offending behaviour, or because of the gravity of the offence, that prosecution is appropriate, or indeed for other reasons that a penalty should be imposed. I don't think it is a relevant circumstance that local housing authorities, as I indicated before, are entitled to keep the proceeds of penalties for their own purposes. That is, if you like, from a local housing authority's perspective, a happy coincidence of imposing a penalty, but should not, to my mind, affect the decision as to whether to prosecute or whether to penalise. The second question from Waltham Forest: will the negative impact of COVID-19 on local government finances influence the choice of CPNs over prosecutions? Well, I think that probably touches upon the answer I've just given, that it ought not to. Although local housing authorities can and are entitled to keep the proceeds of financial penalties, that ought not to be, excuse me, a factor that weighs in the balance when deciding whether to prosecute or penalise. Again, that should be assessed according to the seriousness of each case and on the facts of each case. BCP Council asked, should we always aim to carry out an interview under PACE as part of the investigation before issuing a financial penalty? I certainly don't see the harm in it. You obviously have to be mindful of the time frames within which you have to operate and within which you have to bring a prosecution and a financial penalty respectively. But yes, I think PACE interviews are often invaluable opportunities to find out from potential recipients or defendants if they have, for example, a reasonable excuse for the offence that the local housing authority thinks they've committed. So in general terms, yes, I think that probably is a good idea. How significant, Doncaster asks, is the reasoning behind the matrix for deciding the amount of the financial penalty and the structure and clarity of the enforcement policy in achieving a successful outcome upon an appeal in housing cases? To my mind, it is particularly important. Ultimately, the clearer, the more transparent a policy, the easier a matrix is to apply, the more logical it is, and the more guidance it gives as to the factors that should be taken into account and the way they should be considered. To my mind, the less likely it is that a first-tier tribunal will consider it appropriate to depart from that policy when deciding the amount of a penalty for itself. And so I think it's particularly important. Local housing authorities should look very carefully at their enforcement policies and make them as user-friendly and logical and transparent as possible. And needless to say, if I can assist in that regard, I'd be happy to do so. And lastly, is it good practice, Hull asks, to serve a skeleton argument where there is an appeal to the First-tier Tribunal? Well, as I was telling my pupil in Chambers, Christina, who is participating today very recently, I think the answer to that has to be yes. A skeleton argument, whether you're acting for local housing authority or indeed the appellant, is an important opportunity, a prime opportunity to influence the mind of the tribunal before you ever set foot in the tribunal hearing room itself. And it is often very useful to ensure that the First-tier Tribunal is aware of the relevant statutory framework and the relevant case law that they have to apply and the approach they have to apply when considering statutory appeals. So in short, I think yes, it is a very good idea. Well, ladies and gentlemen, I've overrun slightly, and I appreciate that that may have been a whirlwind tour, as I indicated, through the statutory framework. But I hope nonetheless that that has given you a good flavour of the statutory power to impose financial penalties and some of the issues that commonly arise as a result of it. Needless to say, if you have any issues that arise from Section 249A or Schedule 13A, I would be more than happy to consider them, especially on a formal basis. But again, as I did last time, I'm going to say that it would certainly be remiss of me not to mention that I'm not the only practitioner in Chambers who deals with this work. We have a range of impressive juniors. I mentioned some of them last time: Riccardo, Tara, Rishi, Sam, Alex, Rowan, to name but a few, and apologies to those I've not mentioned. At my level of call and thereabouts, you have other impressive juniors, Kuljit and Andy, for example, and then, as I indicated again before, an embarrassment of silks. Ranjit Bose, QC, James Finley, QC, Ashley Underwood, again, no relation that I know of, Calvin Rutledge, Matt Hutchins. So we have a range of practitioners. However complex the issue you have, we have the barristers who can deal with it. So do feel free to get in touch. You have my contact details and you have the contact details of clerks in Chambers. That said, that brings to an end today's webinar. I hope that it's been helpful to you. I hope that you've enjoyed it. Tune in again. This won't be the last on this subject area. And I look forward to seeing you participating in another in due course. Thank you very much.